estate planning 101, what every family needs to know. And this is really focused on California families, but even if you're not in California, this can still be useful. And if you have a plan, it's a good refresher. If you don't have a plan, you really need to watch this. And as we jump in, we thank you so much for spending time with us. And why did you join us here today? Ask yourself that. Are you worried about your finances? Are you worried about making sure they stay managed if something happens to you? Worried about your health, your future, your family's future? Or do you just feel overwhelmed? And needless to say, we live in unprecedented times. Stock market's been crazy the last few years. We've had pandemics, there's political divisions, there's so much uncertainty. And from our perspective, we are shocked. There was a recent study that came out from caring.com that said that 65% of Americans don't have any estate plans into place. We're here to help with that. And we want to hammer this message home. Control what you can control. There's so much in life that you can't control. Let's talk about what we can. And estate planning is something that you can control that can make a huge difference. And this talk will give you the key steps you can take to protect yourself and your family from a legal planning perspective. So let's jump in to our topics here today. Mike, why don't you lead us through what our subjects are today?
Sure. So this is kind of the overview of what we're going to cover today on your behalf, being very practical. The three essential critical documents that you need to have, that your family members need to have, they're just fundamental. Next, some secrets to protecting the estate, particularly for your kids in the event they ever have a divorce, they're sued, protecting them from estate tax exposure. It's just remarkable what we can do that is protective. We're certainly going to talk about the new property tax laws here in California, which are time bombs waiting to go off. We'll go through a couple of nice stories to make this point. And bottom line is, how do you put a plan into place, or how do you review what you have already in place? Because again, it isn't that you do it, oh, I did it 20 years ago, I'm done. It's got to be timely. It's got to reflect your wishes. So we're going to walk through the issues you need to think about and the documents you need to put into place. Real practical here today.
Yeah,
so let's tell some stories.
Let's tell some stories. And if you have questions, please put them in the Q&A function. We'll try to get to those as much as we can at the end. We have a lot to get through here today. We like to tell tales to illustrate some key points. So let's just do a quick tale. You may be familiar with this one. Larry versus Wyatt, a tale of supercharging a plan. Each of them gets $2 million from their parents. Larry inherits $2 million, so does Wyatt. But because of the way it's done, Larry, imagine them leading the same lives. He endures a divorce. He loses a lawsuit. When he passes away, of that $2 million inheritance, it's all gone. Nothing for his kids, and of course, nothing for his grandkids. Wyatt, on the other hand, he also gets divorced. He also loses a lawsuit. But when he passes away, that $2 million is now worth $6 million. And when his kids pass away, it's grown to $18 million, an $18 million difference. What is the mystery? We're going to explore that.
So let's tell another story, and this is going to focus on the family home. This is an issue that I believe everybody on this webinar will relate to. Okay, three individuals, similar situations. Tom has a $3 million residence, current market value. The assessed value is only $300,000. Prop 13, bought it a long time ago, that established the assessed value and the property taxes. Okay, Tom passes away in 2022, and his daughter inherits the house. She said, what a deal, I'm going to rent it out, what a great deal. Property taxes go from $3,000 to over $30,000 a year. Pretty dramatic. Jill, she inherits the residence. So I'm sorry, Jill has a typical, the same profile, same values in terms of assessed value, same value in terms of market value. At her passing, her daughter inherits the residence and decides to live in it. She moves in. You might think, no property tax increase. Wrong. Property taxes in her situation go from $3,000 to over $20,000 a year. Amos, our friend Amos, identical residence, same profile. At his passing, daughter takes over ownership. And whether she lives in it or not, property taxes remain at $3,000. So how can this be? What's the difference? What's the mystery here? We'll revisit.
And so you guys, by watching this, are going to be way ahead of the game, by the way, for 98% of California families. And just to illustrate the core of what we're talking about here, I want to tell a real story. This is Charles. This is not an actual photo of Charles, but Charles is not actually the full name. But he was someone who was introduced to our office. And I think his story illustrates why it's so important to have an estate plan in place. So Charles had some kids, but he hadn't talked to them in decades. He was a successful pharmaceutical executive back in the day during his career, but he had millions of dollars in the bank and he owned a house in Mountain View. So his estate was quite large. But one of his neighbors saw that things were falling apart. She was kind of helping him out, taking him on walks, and she saw that his house was in disarray, dishes were piling up. He clearly was not taking care of himself. And so she actually called our office to try to help us to speak with him to set up an estate plan to make sure he could get help. And we had a call. I actually had a call with Charles. It was a good call. He revealed to me that he had some distant family members he hadn't talked to in a long, long time. I think he had one son who he hadn't talked to in decades, and he had a falling out with him. He didn't have an estate plan in place. He had a very simple will from decades before. And we came up with a plan to set up a good set of supporting documents, a trust, a power of attorney, advanced directive, to make sure that he could name his neighbor and other people that he trusted to step in to help him if and when he needed it. And he named some charities, his college that he attended growing up, and a couple of other charities where he wanted his multi-million-dollar estate to go after he passed away. We started the drafting process. We sent him some drafts, and he calls us and said, "Who are you and why did you send me all this?" He had forgotten everything that we discussed in the meeting. His capacity had slipped too far. He couldn't create an estate plan, so he was stuck without an estate plan. What happened? Well, as his condition declined, Adult Protective Services had to be called. A state agency came, and a state agency had to go to court to get a conservatorship. They took over his life. A state agency took control of his affairs, his financial affairs, his care decisions. He lost all control. And when he passed away, assets went to distant relatives he hadn't talked to in decades. The charities he cared so much about got nothing. He did not set up an estate plan in time. It was too late. And so many people are in Charles's shoes where if something happens to them, nobody's there to help out. And so the state steps in, or worse, nobody steps in. Nobody's notified, and things just get worse and worse. So we don't want you to face Charles's fate. We want to make sure you have a plan in place. And for those of you who don't know us, as we jump into solutions, what Charles should have done sooner, just about our firm. If you don't know us, we're Gilfix and Lopole Associates. I'm a partner. I'm Mark Gilfix. This is Michael Gilfix. We are not the entire team. We have a number of other wonderful estate planning attorneys and tax experts that work with us. We've been around for over 40 years, based in Palo Alto, but we serve clients throughout the state from San Diego all the way up to Wairika. And our goal is to provide extraordinary value and peace of mind to the families that we work with. And we work with thousands and thousands of California families. We're featured in the media. We publish books and articles. We're very proud of our place as thought leaders in our field. And we'd love to get the chance to connect with you. But today is about what you need to do. We'll show you how we can help you with that, of course. And just at a high level. So 2 key points, though. Why you need an estate plan. We're going to go into a lot of details here, but it's ensuring that you're covered in a crisis and keeping things in the family and out of the court system. You don't want your affairs being stuck in the court system. It's also about ensuring that your hard-earned assets go to the ones you loved with the right structure in place to protect everything that you've worked for.
And Mark, let me answer you that, you're on this webinar, so you are not Charles, but let me tell you, you know Charles, somebody, a relative, a friend, somebody who hasn't gotten organized, who hasn't taken care of business. So we'd like to delegate you to be an emissary. Make sure that your friends and family members, they take care of business. Spread the sophistication, spread the basics. Sorry, Mark, go ahead. I just really think it's so important.
Absolutely. And what is your crisis?
Yeah, it could be anything. A personal crisis can come up anytime. Objectively, we know this. Most of us tend to be in denial. Anybody can be in an accident. As we age, illness, stroke, dementia happens. It does happen. So obviously, you want to be prepared and not have to deal with these crises without any preparation. If you don't, and if the Charles isn't prepared, as Mark indicated in that very real example, somebody's got to go to court to create what's called a conservatorship. Money, time, hassle. A court member, a delegate, a county employee takes over. Nobody wants that. Nobody wants that. So, most fundamental, the theme throughout here, the most important planning step is talk with your attorney. Make sure that your attorney, presumptively us, of course, knows what's going on, really understands the issues, how to put these pieces of the puzzle together. It's fundamental. What are the key documents? Let's do a refresher and look at that. Again, most of you know this, but it's so important to reiterate. Everybody needs to have a revocable living trust, sometimes called an inter vivos trust. It's got different names. Setting up a trust to make sure there's no probate, all kinds of benefits. Mark will go through that. A durable power of attorney for financial affairs, an advanced healthcare directive. All of these documents have to be up to date. If you have kids, you should do what we refer to as a family protection trust. We'll revisit that. It's a no-brainer. It's a no-brainer if you have kids to protect them and your grandkids.
So now let's talk about revocable living trust, why you need that. I'll go through why a trust is much better than just a will, why you need a trust and not a will in just a moment. But just some keys here. It has to be right for you and your family. There are a lot of tax and control issues that go into your living trust. There are a few different structures we can use. And we have many clients who created their trust 10, 15, 20 years ago, and they haven't looked at it in a while. And the way it's set up could cost their family hundreds of thousands of dollars in unnecessary taxes. Yes, the structure of your living trust can have huge implications on capital gains taxes. And it can also have implications for estate taxes as well. So we have to look at your situation, make sure it's right for you and your family based on capital gains tax issues, based on estate tax issues. You got to talk to an expert to review it at least every 5 years. You do not want a simple off-the-shelf trust. You can download trust. This can be done now, but they miss some of the key issues because there are no simple ways to weigh a lot of the issues that families need to deal with. Don't think, oh, I did one so long ago. It was cheap. It was easy. The stakes are so high. A living trust, just think about this. Everything you work for in your entire life and the person who can manage all of your assets, all of this is governed by this document. It's one of the most important documents you'll ever create. So don't just think, oh, I did a simple one years ago. I'm good. I have a trust. Yeah, better to have a trust than not. But this is a huge deal. And it's very straightforward to make sure that it's structured right for you. So much money at stake, making sure the structure's there, making sure the right people are named. Now, I get this question a lot. Why a trust and not just a will? I have a will. I don't need a trust. If you have a will, when you pass away, even if it's properly set up, all of your assets, unless you have a very, very small estate, if you have over $150,000 or any property, all of your assets will be stuck in probate. And if you love the DMV, you will love sticking your family with probate. It is up to a 2 or 3 year process where your assets are stuck in the California court system. It's very expensive. It's a double or triple the cost of the administration of a trust. It is totally public. So when celebrities pass away and you see everything about their estate plan, like I remember when James Gandolfini, the star of the HBO show The Sopranos, when he passed away, there were all these articles about where his assets were going and what was there. And you're thinking like, why is this all public? Because he had a will, not a trust. It's time consuming. It takes forever. And a will doesn't help you while you're alive. You name an executor. The executor has no role to play until you're gone. They can't even help you. And if you have property in other states, by the way, there'd be probates in every state where you have property. So my dad from Michigan, if you ever get at that cabin you've always dreamed about in East Tawas, you'd have a separate probate in Michigan as well. So it's a horrible thing. A trust keeps things in the family, out of the court system. It also allows you to name successor trustees. People can step in to manage your major assets if you're incapacitated without having to go to court. It avoids probate. It costs less down the road. So it may cost more to set up a trust now, but it can save tens of thousands of dollars down the road, not to mention tax and other considerations. So you need a trust, not just a will. Let's talk about the other key piece of this, powers of attorney.
And as a note before that, this wonderful lady I met with this morning, we looked at her trust, which she prepared many, many years ago. And I pointed out that she's leaving 15% of the estate to her nephew. She literally audibly screamed, said, to him, to that a-hole? To say she's estranged from him is an understatement. It was like a moment of panic. Obviously, we're fixing it. But again, it makes the point that Mark made. You got to be thoughtful about these things. You got to review what's going on. All right. Power of attorney. This is the document where you appoint somebody who has the authority to manage your affairs on a daily basis if you become incapacitated. It complements, it works with your trust. Well, the trust controls trust assets. Many activities and assets like retirement accounts are outside of the trust. So it's to the durable power of attorney. So critical. It's not naming somebody as your attorney. In fact, that's the person named in the power of attorney, as is the question with the trust. You don't name somebody you like because they live next door. You name somebody who's responsible. That's a key decision that you have to make. Not a check the box form. We think you know that. Simple forms don't always work. Powers of attorney are historically and often abused by wrongdoers. So again, it's a matter of choosing the right person, having restrictive language, sometimes accountings. There's a lot of provisions we can build in to prevent that. We've made the point and we make it again. You've got to review these documents, not just in terms of who's named, but does it have all of the proper language? As our last bullet point here illustrates or emphasizes, there's language you need to have in your durable power of attorney to be sure that your agent, the person named as your attorney in fact, can take certain steps, particularly in the context of tax planning and planning to protect assets and qualify for Medi-Cal if long-term care issues ever come up. The simple check the box documents don't work in those contexts. So there is a degree of sophistication needed, and not that length is always a guarantor of quality. Our powers of attorney tend to be 15 to 18 pages single space. They need to be to make sure that everything is covered. So that's the second essential document, the durable power of attorney. Next is the Advanced Healthcare Directive. And here you're doing two things. First, you're naming the person who's going to be your agent, your healthcare advocate. That's the person empowered to make healthcare decisions for you if you can't. And very importantly, to be your advocate in the hospitals. You have to name somebody who's comfortable in a medical care setting, who won't just kowtow to a doctor because the doctor says something. They've got to be your advocate. You could be in the hospital short term and not be able to make your own decisions and express yourself. It isn't that always a matter of dementia and you can't do it in that context. It can come up if you have an operation. So you got to be careful. Again, you don't use the simple forms that check a box. While those usually work, they do. If there's a difficult circumstance, a difficult decision that has to be made, that's where your wishes should have been laid out with clarity. So there's no doubt about what your agent should do in those difficult, often end-of-life decisions. So, it's that old pull the plug issue. How do you want to deal with that? Whatever you want should be explicit in your document. It reflects your wishes, it reflects your values, and we want to make sure that it's appropriate for you. Updating it. Not only do you need to update it to make sure you've named the right person and have the right contents, but some medical care providers worry that a document 10, 20 years old, they would logically say, hey, how do I still know this is what the person wants? Why should we honor these terms? So it should be updated. This document is so critical to quality of life, to your dignity. Financially, it can be important as well. So there you go, the trust, the durable power of attorney, the Advanced Healthcare Directive. And now we'll move on to another level of sophistication here, but still the basics,
Yeah. And I'll just add that same with the power of attorney, you need to update that every 3 to 5 years. That also gets stale. If you try to go to a bank, if you're trying to help out a loved one with a power of attorney that's 15 or 20 years old, banks are always a pain in the butt to deal with. They will be even more of a pain if it's an old document. They might not even accept it. So updating these documents every few years, revisiting them is crucial, not just to make sure they're up to date, but to make sure that when they're presented to hospitals or to doctors or to banks, they're recently created and there's fewer issues. Now, we're a multi-generational law firm. We've written articles about multi-generational planning. We just did a webinar on our Gilfix Law YouTube channel. Look it up, Gilfix Law YouTube channel, on the astounding power of multi-generational planning. But here's one quick tip. We believe that if possible, if you get along with people in your family, you should share copies of your documents with your loved ones, and especially with those who are named. You don't want to name, your oldest daughter and not tell her about it and not give her a copy of the power of attorney or the advanced directive. She needs to know that she's named. She should have copies of this document so she's ready to go. And we often will do multi-generational meetings. We believe that whenever possible, families should work on a multi-generational basis in creating and reviewing these documents. We have hundreds of clients who are members of a program we have called Peace of Mind for people who have set up plans with us. And included in that program is a 1-hour meeting every year, and many families use those to bring their kids in just to review the plan and to review their involvement. So we believe it's great to share your documents. We don't believe in the old school, set up your plan, put it in the safe deposit box and lock it up. No, I mean, maybe if you have severe conflicts in your family, maybe, but whenever possible, you should share it with your family. Now, let's talk about how you can protect future generations. The secret to protecting assets, and that is the family protection trust. It's a type of dynasty trust. Now, why does Bernie Sanders want to ban these? And this is not a political statement. He's on record saying he doesn't want these to be allowed, but they are. Ultra high net worth families have been using these tools for generations, for a long time. There's plenty in the press about this. You can look up Dynasty Trust, been featured in the Wall Street Journal. They can offer amazing benefits. Don't just take our word for it. But our version is a family protection trust. Now, why would you create a family protection trust? We talked about the three documents: the trust, power of attorney, advance directive. If you have kids and you want to protect them in the future, this would be a fourth document, or it'd actually be one for each of your children. So you'd have your living trust. And if, say, you have a son and a daughter, you wouldn't leave money to your son and to your daughter. You create a family protection trust for your son and a family protection trust for your daughter. You wouldn't leave them a penny. You leave it to their trusts. Why? Three big reasons. One, if your child inherits money and endures a divorce, if they commingle those assets at all, they could be lost in a divorce settlement. If you leave it to a family protection trust, they stay separate. They should be protected from your child's significant other if they ever ditch them and try to take the money. Two, if your child is sued, if they inherit assets directly, all those assets are absolutely accessible in a lawsuit. If you have a family protection trust, there's a barrier that makes it much harder for someone suing your child to get access to those inherited funds. So that can often mean the difference of money being lost or money being protected. And this is huge, and it's hard to wrap your head around this. The money you leave your child, if it's left to them directly, it's part of their estate, right? And if they're earning their own money, they inherit this money, all of that is part of their taxable estate. When they pass away, hopefully way in the future, all of that is exposed to estate taxes. Right now, you can pass over $12 million to your heirs without a penny of estate tax exposure. But in 2026, that's going to drop by 50%. And we don't know what's going to happen in 10, 20, 30 years. There could be very strict estate taxes. All of this is exposed if you leave money directly to your child. If it's in a family protection trust, it's not part of their taxable estate. It passes, plus the growth, almost all the growth of those assets through your child's life goes to your grandkids free of estate tax. And you might think, well, these three things are great, but I don't want to tie my kids' hands. I don't want to make it too complicated. Your child can be in charge of that trust. It doesn't have to be a third-party trustee. So if they're responsible, they can be in charge of this trust. So when the money goes in that trust, when you pass away, they have control of the trust and can use the assets largely as they think is wise for their family. So incredibly powerful trust. And when you look across generations, the difference can be massive. And let's go back to that tale we started with. Larry versus Wyatt. Each of them was lucky enough to have $2 million left for their benefit. Cost of a small house in the Bay Area or a small house in Los Angeles or San Diego. Larry, divorce, lawsuit. He inherited it directly. So when he got divorced, he had commingled the assets. Half of it was lost. When he got sued, the rest of it was lost. Nothing for his kids, nothing for his grandkids. Wyatt, on the other hand, the difference here, it went to a family protection trust. So when he got divorced, wasn't touched. The money he inherited was there. It kept growing during his life. When he was sued, the person suing him said, oh, I'm not going to touch that. I don't want to mess with this trust. I'll settle for pennies on the dollar. That money's protected in a lawsuit. So the $2 million, he just kind of invested it decently. It doubles, it triples during his lifetime. It goes tax-free to his kids. It doubles and triples during their lifetime, and it goes tax-free to their kids, a difference of $18 million. And now you can see why we think these trusts are so extraordinary. The families that put these into place, when you look 1 or 2 generations ahead, are going to be so far ahead of the families that don't. And there's no reason this should only be for ultra high net worth families. This should be for anybody who has a house in California. We think that justifies having a family protection trust. That's enough. You don't need to be ultra high net worth. So extraordinarily powerful. Create family protection trusts for your kids. Now, family protection trusts aren't right for everybody. And here's another example of another really powerful tool for a different type of situation.
So here we have a situation where you have a child or perhaps a grandchild with a disability. If your child is not disabled, in other words, able to work, make a living, you would set up this family protection trust. But, it's almost like there's 4 essential documents. We say 3, but that dynasty trust, that family protection trust is just incredibly protective. We view it as a no-brainer. But okay, now different situation. You have a child with a disability. on the autism spectrum, cerebral palsy, whatever it may be, the individual can't work. That's what it comes down to. Can't make a living. In that situation, this is not our topic today, the appropriate trust to set up for that individual, for that child, is called the Special Needs Trust. Mark and I co-authored a book on this, which is available here. I believe it's on Amazon. To our clients, it's free. If you're a client and you don't have it, let us know. We'll send you one. Any amount of money, here's the key point, any amount of money can be left to a properly drafted special needs trust for the benefit of a child, and none of it counts. None of it interferes with eligibility for government benefits like SSI, which is an income program, Medi-Cal, which is a comprehensive health insurance program. The trust is like a lifelong safety net. All the money that you leave is available to supplement what government benefits will provide to that individual who's not able to work because of a disability. So no surprise, we have a webinar on our channel, again, Gilfix Law, on YouTube, on Gilfix Law. We have a webinar on special needs trusts. It's one of our primary areas of focus in our practice. We're very proud of it. It's some of the most important work that we do. I think that's obvious if you have a child with a disability. So that's on the list.
Yeah, let's solve one of the other mysteries. And Mike, why don't you lead us back through Tom, Jill, and Amos?
Let's do that. So here, remember now, this is the family home where we have Tom and Jill and Amos, similar circumstances, deaths occur in 2022, but dramatically different outcomes in terms of property taxes that are levied on the property after the owner, Tom, Jill, or Amos, pass away. Remember, Tom passed away, property taxes went from $3,000 to $30,000 a year. 10 years, that's with increases, that's like $350,000. I mean, that's an enormous difference. Jill, she thought, because she read an article in the San Jose Mercury, that if your child lives in your residence, the property taxes don't go up. And that's wrong. Only the first $1 million in reassessed value is forgiven. So around here, where property values are $3, $4, $5 million and more, incomplete, limited protection. Not a bad thing, but limited protection. So for Jill and her daughter, property taxes, surprise, still went to $20,000. That's an extra $17,000, $18,000 a year. That's serious money. What did Amos do? Well, again, for Amos, the smart guy who got good advice, no property tax increases. The rationale, he planned. He planned. Proposition 19 is the evil source of all of this in this context. Prop 19 did some good things, but here, this was a hidden punishment for property owners. It is avoidable. So the bottom line here for Amos is he took appropriate planning steps. We've developed a number of different approaches that can be utilized to be sure that we preserve low property taxes, whether it's your residence or the cabin in the mountains or the rental, whatever it is. We have developed techniques so that we can preserve the low property taxes for your kids. And again, in so many properties, this is saving $500,000 to $1 million and more over the lifetime of your kids. So this is serious money, not today's topic, but if we're talking about the basics and your legacy and protecting yourself and your kids, this property tax debacle, it's like a hammer waiting to fall on your kids. We can do something about it. So it's got to be on the checklist of items that you would talk with us about, or your attorney if you don't see us, to make sure that you preserve low property taxes, protecting your home, protecting the investment property. And so many of us have investment property. We view that as the key to future financial security. Well, again, it's going to go out the window unless you deal with it. So again, we have a webinar on this. It's on our channel. The key, of course, however, is just dealing with it. Don't think, oh, I'm going to look at 3 more webinars. Deal with it. If you have this issue, talk with us, learn about the options, take some planning steps here that go a little bit beyond the basics, but essential.
And we've helped hundreds of families already deal with Prop 19 successfully. And we're one of the first firms in the state to really understand the issues here and to develop solutions. And there is no one size fits all solution for this. It really depends on your situation, but we have them. Some of the key decisions. So let's circle back to the core documents and some of the key decisions that you and your family have to make. So in all these documents, you have to name successor trustees or people in your attorney in fact in your power of attorney form, which is, by the way, is such a confusing term. Attorney in fact. People say, aren't you my attorney in fact? And in fact, we are their attorney. Not their attorney, in fact. Anyway, who are you naming to step in to manage your affairs if you are sick, if you're incapacitated, to oversee your estate down the road? And it's not about who you love the most. A lot of our clients are like, well, I don't want to favor one kid over the other. It's fine to favor one kid over the other. It's actually a big responsibility. And if you don't have any friends or, sorry, family members or very close long-term friends who you really trust, you can always look into professionals. There are professional fiduciaries. Sometimes we attorneys do it. There are trust departments at banks. So you need someone to step in, and ideally a couple backups. You have to really think about this, talk to your family about it. And you have to think about on the healthcare side, the financial side is governed by your trust and power of attorney. The healthcare side, it's your advance directive. So those are often different sets of people. You have to be really thoughtful about this. Now, how do you put these into place? Well, you got to work with an attorney. If you're just out of college and you want to get the very basic into place, you don't have a family, any assets, maybe it's okay to do your own documents. But if you have a family, if you have kids, if you have a property, if you have significant assets in the bank, anywhere in the six figures, you need a trust, especially if you have kids. Meet with an attorney. We work with people, again, all around the state of California. Zoom has made that really easy. It's been that's one of the good things about the pandemic. We've been able to meet with families everywhere. Make these decisions with expert guidance. We talked about the trust, your living trust. There are a few different alternative structures that can have a huge impact on your family's future. There are other tools we may want to put into place. You got to think about property tax issues, and you have to make sure that these are all done right, that they're up to date. So again, it's the big three documents: trust, power of attorney, advance directive, and really, if you have kids and want to protect them, family protection trust as well, or if a child with a disability, a special needs trust. You meet with an attorney, and when we work with clients, we meet with them, we develop a plan, we send drafts, they're approved, the client signs them, and you're done for a while until you need to revisit it. The good thing about estate planning documents, once you set it up, it's there to protect you. There's no monthly fee to keep a trust up to date. Yeah, you're probably gonna have to update these documents, but once you have it and once it's updated, you have that safety net there to make sure that you're covered. Again, we encourage you to communicate with your family and loved ones, and we've helped, again, thousands and thousands of California families to put these into place. Let's just talk, by the way, we get this question a lot. What if there is an emergency? How do you get these into place? How do you use them? Mike, why don't you talk about that?
Sure, let's go through the basics. So if you have a trust, you would be the trustee. If you're a married couple, the two of you would be co-trustees. If one of you is ill, the other takes over without any paperwork usually. But what if you need the alternate? If you're a single person, for example, and you can't serve as trustee, you can resign. If you're feeling that you're just not able any longer, you're just tired of it, you can resign and your successor trustee takes over. The alternative, which is a little more complicated, of course, is every trust says that if the trustee, that's you at the beginning, if you become incapacitated, if you become unable to manage the trust and discharge the responsibilities as trustee, the alternate trustee takes over. You need to document that. That can be a little difficult logistically, but it can be done. So there are steps that have to be taken. And once another trustee takes over, that has to be communicated to financial institutions that hold your assets. There's a number of follow-up steps, very routine. Okay. The durable power of attorney, how does that go into effect and when does that come up? Again, retirement accounts are maybe the easiest example, or a bank account that you didn't title in the name of your trust. Copies of the documents need to go to the entities that you need to respect the documents, sort of obviously. If you have a bank account at B of A, your agent, the person you name, would need to bring the document, sort of obviously, along with him or her, to make sure that they're going to have access to your account. It doesn't really work to send a power of attorney, a thick document, to a bank in advance. They usually don't have a mechanism for maintaining it. So you have to educate the people you name in these documents so that they know what to do. Pretty basic. Same for government agencies. If the document's going to be utilized, it's a matter of making sure that you have access to those documents, as does your agent, the person you've named. And same for the advance directive. I mean, these are kind of obvious, and yet we know from experience they're not. Your advance directive, most doctors and hospitals will accept a copy and put it into your chart, your file, and it will be available going forward. So you want to do that. Make sure that they have an up-to-date copy. They know what your wishes are. They know who is named, and then the individual can step forward and already have the document in the right place. dramatically enhancing the likelihood that the person of your choice is going to have authority to make medical care decisions for you. Have extra copies. Give them to your agents. We stress the involvement of the next generation, the involvement of the people to whom you've given responsibility. If they don't know they have that responsibility and accept it, you can't really be sure they're going to accept that responsibility. So have extra copies, share them. We always have copies available through our office, of course. Make sure they're accessible.
Yeah, we don't know what your crisis would be. Setting these up ahead of time, taking all the steps that Mike just outlined is so crucial because you don't know what could come up. A stroke, dementia, car accident. So many things can put us out of commission for the short term or the long term. Maybe you face expensive long-term care. Maybe a child suffers a divorce in the future or gets sued. COVID-19, long-term illness. When you pass away, that's another crisis for your family. Property taxes going up 1,000% or more. These are all crises that can be solved or at least mitigated if you have the right estate plan into place and ensuring that you do it the right way. So what are the things you can do to protect your family and to preserve your hard-earned legacy? Well, we've kind of talked about it. We're just going to hammer it one more time. Some of the key things. We're going to get to just a couple really good questions, by the way. Well, I think the first thing we like to say is overcome the 3 Ds, the danger of delay and denial. We have the ostrich there. Don't have your head in the sand, as ostriches like to do. We hear these lines. My kids won't ever divorce. It's fine. I'll check back in 10 years. We hope not. I'll get to this later. I don't need to deal with this now. I'll live forever. It's funny how many of the clients that I've worked with who say, if I die, it's like, I mean, I hate to say it, but we're all eventually going to death and taxes, right? Or I already have documents. These are going to be enough. I did it a few years ago. Or I don't want to deal with a lawyer. I don't like dealing with lawyers. It'll be fine. We promise we're not like the normal lawyers you see on TV. We're not douchebag litigators. We have amazing litigators. They're very kind people. So if you do have litigation issues, we can help. But this is a different area of law. But you really need to work with experts. Again, it's everything you've earned your whole life, everything you've worked for. That's what this is about. It's about protecting it and keeping control for you and your family, not turning it over to the courts or public systems. We have many webinars on this. We have webinars on this topic, but also about special needs planning on property tax issues. Check out our Gilfix Law YouTube channel. But while you're thinking about this, we can help you with your dreams and your legacy, and we can help you to keep control. That's what this is about. It's not dry legal documents. They serve the purpose of allowing you to keep control and autonomy. So we, of course, would love the chance to get to work with you and your family. If you've already worked with us in the past, of course, reach out. If this stoked a new idea of, hey, I want to revisit this, or I got to think about this property tax issue, or, hey, my trustees might not be up to date, or I'm not sure if my trust is right. Talk to us. Whether you have a plan and you just want to review it, we can help. If you don't have a plan, of course, we can help to make sure you set it up the right way up front. We can review your existing plan. We can help you update it. We can help you create a plan. Of course, contact us. You can call us 650-493-8070, gilfix.com. If you want to contact us through our website, there's a checklist you can check for issues you want us to focus on, gilfix.com/my-needs. We would welcome the chance to get to connect with you. And we have just a couple of questions I want to get to. One good question: what is the best way, from Dan, and then we're going to wrap this up soon, to avoid a challenge to your trust or your will down the road? Setting it up right up front is the key. If you work with an attorney, it's one of the biggest values of working with an attorney. If you set up your own trust using an online program, who's vetting that for you? Who's witnessing you signing it? Who's talking to you to verify that what you're saying is really what you want? You need to work with an attorney up front so we can ask the right questions and make sure we've documented everything properly, and then we can defend your estate down the road if there's ever a challenge. But the key thing is, as long as you have capacity and as long as you aren't being influenced by bad third parties, what you say goes, even if some family members don't like it. And if you set it up with an attorney, we can make sure that it's as challenge proof as possible. We also can build in provisions that say if anybody challenges this, they are disinherited. So there's a few different ways we can address that. Anything you'd add there, Mike?
Yeah, seeing an attorney is a good thing, but obviously it has to be an attorney who understands this area. There are two primary grounds for challenging a will or a trust. One is a lack of capacity on your part, and the other is something called undue influence, where somebody is influencing you to make a certain decision. So understanding the depth of that and how it's argued, we address it in advance. So if there's any indication of dementia, for example, we may have you meet with a geropsychiatrist. We address the issues that we see that could be grounds for a challenge. There has never in our 40 years been a successful challenge to any trust that we've created. Never. There have been challenges that have been initiated, but they've always withstood challenge every single time. Best answer.
Yeah, that's the key. And we have a good question. Someone else, what are the living trust implications if that one spouse is not a U.S. citizen? Talk to us. It really depends on your situation, but you need to work with an expert attorney on that. We can help you work with many clients where one spouse is an American citizen, the other is not. There are different issues you need to be aware of there.
Yeah,
so
it's not, it works. Let's just say living trusts certainly work. Sometimes there's some different provisions we have to build in.
Right. It would be the structure of that. And we have questions, and this is a common question, how do we work with families? And the simple answer is we want to serve you from the moment you come to meet with us. We are blessed to have a large and growing client community. We don't do free initial 1-hour consultations. When you're sitting down with us, we're there to work for you and work with you. So we bill hourly for our initial planning meeting. Now, if you have questions about whether we're a fit and you want to make sure that we can help serve your family, we can do 15-minute initial Q&A calls, again, just to make sure that we're a fit for you and your family. But if you're ready to get going, get it on the calendar. When these things drift, problems happen. People put it off, they put it off, they put it off. So set a time with us. We'd love the chance to meet with you. Gilfix.com is the easy way to find us. Gilfix.com/my-needs. Any other final thoughts, Mike, before we wrap this up?
No, I think we've covered the basics. Most folks who attend our webinars tend to have things in place. You're by your nature, by being here, it suggests that you take care of these things. That's why I think it's so important to be the emissary, to think about other family members and friends who may not be as up to date as you are, and really not understanding how vitally important, how it sometimes swings hundreds of thousands of dollars in the appropriate as opposed to the inappropriate directions. So, just to reinforce, it's the obvious, take care of business. Let's make sure we all do.
The stakes couldn't be higher. Take care of a plan, get it into place, make sure it's updated. There is so much that we can do to protect ourselves, our legacy, our autonomy. We'd love to get the chance to help you, but yes, spread the word, subscribe to our Gilfix Law YouTube channel, and contact us if we can get the opportunity to serve you and your family. As my mom always likes to say, I hope everybody's staying safe, sane, and healthy, and we hope to talk to you again soon. Take care, everyone.
Bye.